afternoon. I'm Ruthi Rajan, Deputy Editor of the Oath Legal Magazine. Joining me today is also my colleague Sandhya, who is a co-organizer of the session. Thank you for joining us for the Oath GC Talk webinar series, an initiative by the Oath Magazine. The current crisis has had all of us adjust to a new normal, not just in terms of work, but life in general. Despite rapidly changing circumstances, we are grateful that we can continue to stay connected to you through these platforms. Our webinar this afternoon is in association with the law firm Charles Russell Speechlys and supported by LLoyd. The session will focus on COVID-19 and conflict, preparing for and managing disputes in the current crisis, led by Patrick Guerin. Patrick Guerin is a partner and head of Charles Russell Speechlys Middle East practice. He specializes in all areas of dispute resolution with particular emphasis on banking, IP, insolvency, professional negligence, and company disputes. Patrick is a fellow of the Chartered Institute of Arbitrators and also leads the firm's International Arbitration Group. To give you a quick overview of the session, Patrick will be discussing the mechanisms that can be adopted to effectively prepare for and manage the disputes that do arise during the current crisis. He will offer practical advice on the varying approaches of the courts in various jurisdictions, pre-dispute preparation, virtual case management, disclosure, witnesses and experts, and preparation for virtual trials. Patrick will lead the session for the first half, and this will be followed by the Q&A session. Some of you have sent in your questions in advance. Thanks for that. These will be addressed in the course of the session as much as possible. There is also an option on your panel to type and send in queries that you may have that are relevant to the discussion. We will try our best to address these questions within the hour. Over to you, Patrick. Thank you.
Thank you very much, Ruthi, and good afternoon, everybody. I hope everyone is safe and well. If we can move to the first slide. This is a bit about me, following on from Ruthi's introduction, and I thought I'd share a picture just to remind us all of a time before the phrase social distancing existed. Next slide, please. So we'll start with the nature of disputes. Next slide, please. Disputes arise from a number of causes, but in our experience, the most common causes are these: genuine grievances, where parties genuinely believe that they've been wronged in some way, that a breach of contract or a breach of a duty of care has occurred. Many disputes arise sheerly out of misunderstandings between parties as to what their legal obligations and rights are. More sinister, those parties deliberately acting in a manner to obtain commercial advantage. The classic example of that is a larger business effectively unilaterally varying trading terms in times of difficulty. Then you have the straightforward old-fashioned dishonesty cause of disputes, and a rather sort of catch-all at the end, which is the use of commercial pressure via litigation or arbitration to achieve a commercial aim. None of these causes are stopped by a pandemic. In fact, it's arguable that in situations where, such as the ones we're in at the moment, the incidence of these types of causes of disputes increase, particularly during times when cash flow pressures are impacting entire supply chains from the top to the bottom. Next slide, please. So to start with, every formal dispute resolution process that is available involves broadly the same steps that have to be followed. There's the initial stage of collating together one's evidence that will either prove one's claim or bolster one's defence. Once that evidence gathering stage is complete, there is, in most jurisdictions and in most forums, a requirement to set out one's stall in a letter before formal proceedings are actually started, colloquially known as letters before action. Once the formal process actually starts, there is what is known as the pleading stage, where both parties or multiple parties set out their stall in a formal written statement of claim. That's usually followed by some kind of case management hearing, at which the timetable for the rest of the case is set out. And the first stage, traditionally in that process, is the disclosure of documents. Disclosure of documents varies wildly from jurisdiction to jurisdiction. Broadly, the common law jurisdiction countries adopt a process of very wide-ranging document disclosure as a result of their discovery rules. Civil law jurisdictions have a much more limited scope of disclosure. The usual next stage is witness statements, which are usually prepared and then exchanged. And if there is any expert evidence required, the witness statement stage is then usually followed by the expert witness stage, which is usually followed by either a final hearing if it's arbitration or a trial if it's litigation. So the question arises, can all of those classic stages be dealt with using technology? And as we'll see as we go through this presentation, the answer to that is broadly yes. Next slide, please. So there are various forms of formal dispute resolution. Litigation, which is usually run by the state-run courts, very precise and wide-ranging rules that govern the way in which cases are dealt with. Arbitration, which is a private process by agreement between the parties to the dispute. Independent arbitrator or arbitrators appointed. Can be ad hoc arbitration where the parties can effectively make up their own rules, procedural rules of the dispute resolution process, or institutional, such as the LCIA or the ICC and others, where the rules are sort of pre-set out by the institution. Adjudication is something that's fairly specific to construction disputes, very short, usually 28-day process, where the parties are bound by the result. Mediation, voluntary process, non-binding usually, where the parties agree that an independent person will effectively try and get them to a point where they can reach a deal. Expert determination, usually binding, where the parties agree that they will abide by the decision of a particular expert and will submit their cases to that expert, who will then, usually on paper, decide the rights and the wrongs of the disputes. The final form of dispute resolution is not a formal process, but it's in many cases is the most cost-effective process, and that's just simply speaking to your opponent and trying to resolve the dispute that way. Fundamentally, all of those forms of dispute resolution are capable of being conducted at every stage, remotely or virtually. So with that preamble in mind, next slide please, we'll have a look at the approach that the various courts in our region are adopting, starting with the domestic courts or the onshore courts. Next slide please. So as matters currently stand, the Bahrain courts remain open. However, the courts have limited those that participate in the hearings to lawyers only. There has been an increased use of e-filing of claims with the registry in the Bahrain courts, but they are still having physical hearings, albeit limited in that way. In terms of the UAE and Saudi Arabia and Qatar, all the onshore courts are shut to physical hearings. Video hearings and telephone hearings are taking place in all those courts, although we're told that the priority is being given to only the most urgent of matters. Next slide, please. We are lucky in the Middle East to have both onshore and offshore courts. With the DIFC court in Dubai, that's been closed for physical hearings, and the registry has been closed since the 17th of March. All hearings have been conducted either by telephone conference or by video conference since that date. The DIFC has its own online case management system, which has obviously come into its own. Hard copy bundles for hearings are still possible, but are being discouraged in favour of e-bundles, which I will get onto shortly. There's been a direction that all small claims hearings are by video conference. There are physical hearings possible, but only in extraordinary cases. And even in those extraordinary cases, the participants of the hearing are lawyers only. The Bahrain Chamber of Dispute Resolution Court is operating as normal, although they are instigating social distancing measures within the courtrooms. Both ADGM and the Qatar International Court, no physical hearings at all. Video hearings are de rigueur there, and the ADGM court, similar to the DIFC court, has its e-tribunals platform for e-filing of pleadings and submissions. Next slide, please. So turning to the arbitration centres, with the exception of the BCDR, where it's business as normal, the DIFC, LCIA Arbitration Centre, the ADGM, Saudi Centre for Commercial Arbitration, and the QIC DRC in Qatar are all following the same protocols. No physical hearings, telephone and video hearings only, and all of them have facilities for online filing of both claims and submissions. So turning to the courts outside the region, next slide please. The English courts have actually introduced specific legislation covering what the courts will and won't do, the emphasis being on parties being encouraged to arrange their hearings either by telephone conference or by video conference. The obligation has been squarely put on the parties to arrange those remote hearings, and bankruptcy and winding up petitions have been suspended unless they're very, very urgent. The London Court of International Arbitration, similar to the arbitration centres in our region, emphasis on e-filing of submissions and claims, no physical hearings, and video and telephone hearings. In France, the French courts are all closed still, and no hearings are being held, save in the case of extreme urgency. And those hearings are happening physically as opposed to remotely. And the International Chamber of Commerce Arbitration Centre is not operating hearings in Paris. The registry is working remotely in a similar way to all the other arbitration centres. And in Switzerland, no hearings, save for those urgent matters, and those urgent matters are only dealt with by video hearing. So the message from all of that is that, with some notable exceptions, the investment that the courts and the arbitration centres around the world have made in the last few years in virtual technology has meant that most, if not all, have been capable of carrying on both the administration of cases remotely and that hearings have continued to take place. Whether this is the new normal in the long term is yet to be seen, but it certainly looks like it will be the new normal for some weeks yet. So next slide please, turning to how one should prepare. Starting point is how do you win a case that has to be conducted in the current climate. There are different definitions of win. Each case will have a different definition of win. It may mean just a straightforward defeating the claim that is brought against you. It may be that you are the defendant and a win to you is you are the claimant and defeating an opponent's defence. It may be that you know that you're not going to win a case outright, so it's a case of a win being mitigating your exposure to the claim. It may be a very strategic dispute in which the outcome that you're looking for is to obtain more market share or to unblock some form of deadlock. Next slide, please. This is bringing dispute resolution down to its most simplistic in terms of how cases are won. Cases are won on the law and on the evidence. The two are, of course, interlinked. The law will be applied to the facts of the case, and those facts will in turn derive from the evidence in a case. We're dealing primarily with evidence on the basis that the law will be explained to whatever tribunal you end up in any event. Next slide, please. In terms of evidence, there are basically three forms. There are the contemporaneous documents that were created at the time leading up to the dispute. There is the evidence of witnesses of fact who primarily are there to provide a tribunal or a court with verbal evidence that would fill in the gaps that isn't covered by contemporaneous documents. And in many cases, where there is a technical aspect to the case, the third form of evidence is expert opinion evidence. In every form of dispute resolution, the evidence that's always given the most weight is contemporaneous documents. And as I'll get onto later in this presentation, that is even more so now when so many cases are being conducted on a virtual basis. So planning for your dispute in the current environment. Next slide, please. And the next slide, thank you. So what I mean by starting assumptions is really setting of a mindset in the current climate. Any negotiation, even the most preliminary, can end in a dispute. That negotiation may have taken place many months ago, but because of the current situation has now ended up in a dispute. You should also think that any transaction that you enter into, that your business entered into, can potentially end in a dispute. You must always have at the back of your mind that people can just be outright dishonest, but they can also be one level down from outright dishonest in terms of their propensity to twist facts if they consider that they can get away with it, or that by twisting those facts, it can give them a financial advantage. The other thing that we commonly discuss with clients at the moment is whether simply settling out a dispute very early on not particularly great terms is necessarily cheaper than putting up a fight to that dispute. And it is certainly not always the case that early settlement is cheaper than fighting. Next slide, please. So how do we go about creating the protection that's needed to deal with those starting assumptions? The first is technology, and to make sure that you have technology in place that enables you to build up an electronic paper trail of documents and ensure that that system is robust. One other thing to ensure is that in relation to future disputes, online data rooms are going to become increasingly important. Rooms that you can install and store documentation in, which can then be shared with others, such as courts or arbitral tribunals. So make sure your IT system enables you to do that. The next is really file management, creating folders for each negotiation or transaction that you're working on, making sure that those folders are backed up, that you have a hard copy version and an electronic version. And scan, save and retain every single communication electronically, even if that communication has come in hard copy form, so that you have in an e-filing system a complete record of that negotiation or that transaction. The next point relates to the chronological ordering of that file that you've now created. And the reason why it's important is that if you ever get to a hearing, the judge or arbitration panel will expect the documents to be arranged in chronological order. And that means that your lawyer the first thing your lawyer does when you instruct them to deal with the dispute, that is what they will do. If you do it, it saves your lawyer doing it, which means that saves you costs. You should also make notes of all conversations. Merely leaving a conversation as having taken place is not sufficient. So make notes of those conversations, record those notes electronically, and again, chronologically. It's always a good idea during times such as these, after a conversation, to confirm the contents of that conversation in an email. Sometimes even better than just making a note of the conversation. In terms of meetings, if they're video meetings or even physical meetings, make a minute of those and again store them electronically and chronologically. It's always a good idea to send those minutes to the attendees of that meeting after the meeting by email to ask them to confirm that they're happy that the minutes are an accurate record of what was said. All of this probably sounds incredibly self-serving, but there's a reason for it, and it's a good reason. If an opponent, particularly an opportunistic opponent, understands that you are creating a very clear record of the negotiations or of a transaction, you are less likely to get opportunistic type claims. Next slide, please. So in a sense, what we're advising you to do is to assume the worst and plan accordingly. So ensure your data storage and your servers are secure and accessible. Never leave emails and letters unanswered if you can possibly help it. Never think that a call will be enough. Minute all calls and meetings, and do not be shy about openly disagreeing with your opponent's recollections or claims. In short, write in a protectionist manner. Next slide, please. And if you do that, Most disputes will be resolved, in our experience, at an early stage, once your opponent realises that your paper trail is good. And as I said earlier, you will get fewer opportunistic claims, and of those that do happen, you will win more of them because you will have the better record. Next slide, please. So if you follow those steps in terms of your own internal document management, the managing of a dispute, which, despite your best efforts, has resulted from a transaction or a negotiation. The current climate and the emphasis on e-filing and virtual hearings and telephone hearings means that a much greater emphasis on written statements of case and written submissions is taking place and will continue to take place. It is now more important than ever that written statements of case are as full as possible and deal with every legal and factual dispute in the case. Tribunals know and courts know that video and telephone hearings are imperfect and will rely more and more as the pandemic and its consequences continue. Those tribunals and courts will rely far more on written submissions and written forms of evidence. And equally, and for reasons I'll get on to later, tribunals are likely to put even less weight nowadays on witness evidence given virtually. They know that body language is important in cross-examination, for example, and they know that that's more difficult in a virtual context. So going to be far more reliant on formal written forms of evidence and submissions. And for all those reasons, the independent contemporaneous documents in relation to a case are even more important at this time than they were pre-pandemic. Next slide, please. As many of you will know, one of the most expensive stages of any formal dispute resolution process, particularly litigation or arbitration, is the disclosure process. Document management flows from the disclosure stage all the way through to the trial or final hearing. So limiting documents, in short, limits costs. So the e-filing that we recommended that you adopt earlier in this presentation is crucial to that. From that e-filing, you should be able to very easily distill your own documentation down to what is essential and relevant to the dispute which has to be resolved. But you also need to be tenacious in your approach of your opponent's approach to document management, and a tenacious emphasis on relevance is important. Particularly those operating in the common law jurisdiction tend to throw every single document that could possibly be even remotely relevant to a case in a disclosure process. That just increases the costs. In the arbitration context, the IBA rules for common law disputes and the Prague rules for civil law disputes provide very good guidance on limiting the scope of disclosure down to very, very strict relevancy criteria. You should also, during the dispute, not be shy about providing your opponent with costs warnings as to the volumes of documents that they are deploying in their disclosure, with a view to keeping the costs down and with a view to transferring the costs you have to incur with dealing with those documents onto your opponent. If you have followed the advice given earlier, then electronic disclosure is far more cost efficient than hard copy disclosure, particularly if the system that you use for your e-filing is searchable by word searches, for example. Next slide, please. So the next stage in any dispute is usually the witnesses of fact stage, and there's no reason why witness statements cannot be prepared and served completely remotely. Witness evidence should be addressed to the key factual disputes in a case. The statements of case, the pleading stage, usually the particulars of claim in litigation, and the defence served to meet that, will and should set out clearly what the factual disputes are between the parties. The witness evidence stage of a case is to address those factual disputes. It's not for opinion. It is not for the life stories of the witnesses. It is purely to deal with the factual disputes. And again, should only really address those disputes that aren't made clear by the contemporaneous documentation outside. E-signatures is an issue. Various different jurisdictions have different approaches and rules to whether or not they will accept e-signatures on witness statements. So be careful as to the tribunal or court that you're in, and whether the approval of the tribunal or the court is needed for e-signatures to be permissible. Obviously, in the current climate, courts and tribunals are being far more lenient on that. Advice should also be given to witnesses as to the meaning and risks associated with the statement of truth, which traditionally appears at the end of a witness statement and is effectively a declaration as to the truth of the statement. Statements of truth in England have recently been amended to include specific reference to the fact that witnesses can be liable for contempt of court if anything in their statement turns out to have been deliberately untrue. Next slide, please. Expert evidence. Again, there is no reason why the expert process cannot be undertaken remotely. Again, the statements of case will determine what the expert issues are. There will usually be a direction from the court or the arbitral tribunal as well at the case management hearing stage as to what the experts are to be dealing with and what they're not to be dealing with. You should always think, particularly at this time, of either a joint appointed expert or a court appointed expert, as that's cheaper and more cost effective and usually quicker. Again, there's an issue of e-signatures, but that depends on the tribunal you're in. And again, warnings as to the statement of truth. What we have seen already during the pandemic and what is likely to continue is a fairly high level of intolerance from the tribunals and the courts as to adversarial experts, guns for hire. In the current climate, it was frowned on pre-pandemic, but in the current climate, it is even more frowned upon by the courts and the arbitral tribunals. Next slide, please. So some guidance on once you've gone through your pleading stage, your disclosure stage, your witness statements and your experts, and you've got all that electronically, either if there's an interlocutory hearing, a pre-trial hearing, or it's the trial hearing itself, the guidance for electronic bundles is the same. These suggestions that we set out in this slide are derived from various sources, and we think these are the best of the guidance that has been released by some of the courts and some of the arbitration tribunals. So an electronic bundle that's delivered to a tribunal or court should always be a single PDF version. It should be numbered in ascending order, regardless of whether multiple documents have been combined together or not. Index pages and legal authorities, extracts from legal textbooks or cases should be numbered as part of the single PDF document so that the court receives just one document. Check the default display view size on all the pages of the PDF, because it should always be 100%. And this is very important. Text on all the pages must be selectable so that the judge or arbitrators can add comments and highlights to the texts. The resolution on the bundle should be reduced to about 200 to 300 dpi. That'll delay any delays in the judge or the arbitrator being able to scroll through. You should have an index page at the beginning of the PDF document that is hyperlinked throughout the index to the various pages and documents you refer to. All of these things are there to make the judge or arbitrator's life easier, and therefore they will like you more. Next slide, please. So hearings generally, from the research we've undertaken with the various courts and arbitration institutions, this is what we're being told. Civil cases in all of those forums, injunctions and breaches of injunctions are being given priority. Court of protection, issues about care, abduction and emergency protection from debt claims type cases are being given priority as well, and also landlord and tenant disputes where there is a risk of people being evicted from premises are also being given priority, none of which is particularly surprising in the current climate. So in terms of remote hearings, there are two basic types. Next slide, please. In relation to both, it will be necessary in pretty much every one of the hearings to create the electronic bundle we've already discussed, and it should be indexed and paginated in the way we've suggested and provided to the clerk of either the tribunal or the judge well in advance of the hearing. Again, there's going to be a focus and an increasing one on non-essential documents being stripped out, so that it is only documents that are essential for the tribunal or judge to see that are in the bundle. And they should be filed and sent either by a link to an online data room, which is becoming increasingly popular, or emailed or a USB stick delivered to the tribunal or court. During the hearing itself, log in good time. Judges will be invited by their clerk or the tribunal official, and the hearing will either be recorded by the tribunal's clerk or the tribunal official or by the judge, unless that's been dispensed with. And it's always possible, with the tribunal's permission, for arrangements to be made for the hearing to be privately transcribed. With telephone hearings in particular, next slide, the key, I think we need to go, yes. So telephone hearings in particular, when will these be chosen by tribunals or courts over a video hearing? There is a cost difference between telephone hearings and video hearings. It's not huge, but it's nonetheless significant. It appears that procedural hearings only will be favoured in terms of telephone hearings. Things like listing hearings, interim applications of no more than an hour, and purely costs management or procedural management hearings will be conducted by telephone. Those that won't, any without notice applications, such as injunctions, hearings where none of the parties are represented, so they're all appearing in person, and any hearings of more than four parties. Across the board, it seems to me that those sort of hearings are not accepted by the courts or tribunals as being appropriate. For a telephone hearing to be a telephone hearing, you normally need the consent of all the parties, although we have seen tribunals and courts ordering them, even if one party disagrees with the fact that they should be telephone hearings, if the court is satisfied that whatever needs to be dealt with at that hearing can be dealt with satisfactorily over the phone. Next slide, please. So where the court has ordered a telephone hearing, it's down usually to the applicant, the person making the applications, legal representatives, to arrange the hearing, which means finding out the right phone numbers for the advocates, the other legal representatives and the court, arranging with a recognised and approved provider, particularly if it's a court ordered telephone hearing, and give that provider of the telephone conference the time, date and numbers for everybody, and the sequence, importantly, in which people are going to be called on to the telephone hearing, with the applicant's representative going first, then any other opponents, and then last the judge. And ensure the call is connected at least 10 minutes before the hearing started, and then open the hearing in the usual way with introductions. Next slide, please. One of the advantages of telephone hearings with approved providers is that they will automatically record the hearing and retain the recording of that hearing, so that transcripts of that hearing can be obtained later on. Next slide, please. So what we've dealt with so far are telephone hearings, which primarily will deal with pre-trial hearings. I haven't heard of any actual trials or final hearings being conducted by telephone, and I doubt that will happen. So final hearings or trials that are going to happen remotely are going to be by video. So in terms of preparing for a final hearing or a very substantive interlocutory hearing, Things to think about are the Wi-Fi capabilities at your end. Make sure the technology that provides these video, and particularly combined video and document management platforms, are data heavy. So you will need a strong Wi-Fi signal to make sure everything runs properly. Do think about, as I've mentioned, integrated video and document management platforms, where the tribunal, the judge, the advocates, and the witnesses will all have at least 2 screens. One screen with video so that the witness can see the judge and see the advocates, and the advocates and judge can see everybody else, and the other screen to put up any documents from the e-document bundle that is prepared, so that witnesses can and the judge and the advocates can have documents in front of them, as well as seeing everybody else. Another thing that can be integrated into those sort of platforms is real-time transcription, which is, as it says, in real time, what is said by the advocates, the judge, and the witnesses is transcribed, and people can, in the courtroom during the process, can refer back to answers that were given, say, 5 or 10 minutes previously. When setting up the forum, do bear in mind time difference issues. You might think this is obvious, but actually in cases where you may have to persuade witnesses to come and give evidence at a hearing, your ability to actually be persuasive and convince them to do so can be heavily influenced by the time of day that witness is expected to give up. So always try and make sure that your witnesses are in a time zone whereby they will be giving their evidence during normal business hours, as that will improve the prospects of them actually turning up and giving the evidence. Testing is vital before the hearing, just to make sure that everything works. Another key aspect is setting up a WhatsApp group with your team, your client team, and your legal team to enable offline communications to be given, instructions to be taken, and maybe changing, advice as to, or instructions as to changing tack with a particular witness or on a particular point of law. Always good to have a backup plan in case somebody's Wi-Fi dies during the hearing, temporarily or otherwise, and protocols for speaking and interruptions. The usual one being that anybody not speaking should have their microphone on mute and their camera turned off. Always good also to arrange video breakout rooms, so that during the breaks, of which there are more tend to be more during virtual hearings than physical hearings, that there is some video space for you to go to discuss how the hearing is going with your lawyers. Dress for tribunal, I'll get to at the end. In terms of the most difficult thing in terms of hearings is video evidence. It is known and understood that cross-examination of witnesses is much more difficult by video. It impairs the tribunal's ability to assess credibility and strength. One of the reasons for that is that it's more difficult virtually to see body language. But the technology has improved dramatically, and to avoid things like off-camera coaching, I had a trial a year ago now that used rotating cameras to show the environment that the witness was in when they were giving their evidence, to make sure that nobody was providing them with bits of paper or anything off camera. And the other important thing is that the judge or the tribunal are the parties involved in the case that actually have control over the camera. I'll finish with a little bit of guidance from the English courts on court etiquette for virtual hearings, which has been produced by the Family Court in England, which says as follows: the professional decorum should be maintained at all times during a virtual hearing. Advocates should dress as if they're attending court, but advocates are not required to be robed for remote hearings. The background visible on anybody's screen should be appropriate, in speech marks, for a court hearing, and adequately lit so faces can be seen. Participants must ensure they will not be interrupted or distracted during the course of the hearing. And this is the one I particularly like. It is not necessary to stand when the judge joins the hearing. So I hope you found that useful, and then we can now move to questions, Ruthie.
Thank you, Patrick. Thank you for taking us definitely some practical advice there. We do have a few questions in hand. I know some of it will probably be repetitive, but probably we can cover some of them anyway, because we had some attendees joining us midway as well. I think we can just start with the general question at the beginning. Do you see online mediation being used in the MENA region in the near future?
Online mediation is already available and is being widely used. Mediation as a form of dispute resolution possibly isn't as, it's certainly not as well used, isn't possibly as popular as it is in places like the United States or Europe. I know most of the dispute resolution centres are putting an emphasis on mediation. There are discussions at various dispute resolution centres in the Middle East about either encouraging parties to adopt a 1 month stay in a case or a 2 month stay in a case to embark upon mediation, or actually making some form of mediation process mandatory. In terms of whether or not a mediation can be undertaken virtually, absolutely. There is absolutely no reason why. Mediation classically needs 3 rooms, one for the mediator, one for one party and one for another party, obviously more rooms if there are more parties. That can be done by video. And whilst it is not as good as face-to-face meetings, particularly mediation where you're trying to facilitate a settlement, there's no practical reason why it can't happen.
Thanks, Patrick. There was also a question on, has anyone experienced the experience of a virtual hearing, if you have actually undergone it, and if you can give some insight into how effective it was from a practical standpoint?
Probably the biggest hearing I've done, which was totally virtual, was a claim where the trial was taking place in the Cayman Islands, but several of the key witnesses for one party were in Saudi Arabia, but were subject to travel bans. So a virtual courtroom had to be created in a hotel in Saudi Arabia where the witnesses were located. And that system used a large screen so that the witness in Saudi Arabia could see the courtroom, and in particular, the advocates who were cross-examining them in the Cayman Islands. But they then had a screen in front of them that showed the documentation that the advocate would be referring to. So again, complete electronic bundle of documents, also live transcription going on screens for the advocates. And that hearing process, certainly in terms of the evidence given in Saudi Arabia virtually, took about a month and was very successful. It all worked, the technology worked. There were obvious time differences between Saudi Arabia and the Cayman Islands, but that was figured out by just sitting, I think the court starting in Saudi Arabia at 4 p.m. and finishing at 10 p.m. But it worked very well. More recently, we've conducted a number of case management conferences in arbitration cases virtually, using a variety of video technology platforms, all of which seem to work very well. And certainly for procedural hearings, there seems to be no real difference at all between virtual hearings and physical ones.
Thanks, Patrick. Thanks for sharing that case example as well. It's definitely interesting. There's also a question about what law or guidance is available to expert witnesses regarding virtual trials.
It's unchanged. I mean, the guidance to expert witnesses in the local courts, in the offshore courts, and even in courts in England and France remains the same. The duties that an expert witness are under are exactly the same as they would be as if that expert witness was standing before a judge physically in a courtroom.
Okay. Then there's a question on how can physical inspections by expert witnesses be organized during a lockdown?
I think the answer to that is very carefully. Obviously, we've got social distancing issues, and there is a case that we're involved in at the moment where the physical inspection of a site is not possible just because of the physical environment of that site and the number of people that are there. It would just not be possible for the expert to visit and be safe in a social distancing context, and that is going to delay the case until such time as arrangements can be made to make that site safe enough for a visit. So there are going to be certain, I think, limited circumstances where site visits won't be possible, but in I think the majority of cases, site visits can be arranged in such a way that there are an insufficient number of people there for it to be safe for those inspections to take place.
Thanks, Patrick. And what about serving summons on new cases? How is that being handled now?
Well, virtually all of the forums that I discussed at the beginning of the presentation, in fact, I think all of them, now focusing on e-filing of claims rather than sending somebody down to the physical court registry to physically hand over a claim form and get it stamped. Virtually every court and virtually every arbitration centre has provision for paying online, whatever fees there are for filing, and for electronically receiving claims and then dealing with the administration of the case thereafter completely virtually.
Okay, great. And are there any specific allowances being made to reflect the difficulty during these current times of gathering evidence and getting witness statements and the related?
Yes, there is a gentler approach to the courts and the tribunals in relation to extensions of time being requested for parties to comply with things that normally wouldn't be too onerous, but in the current climate are more difficult. There's definitely a noticeable gentler approach, as I say. Where the courts are not being more gentle necessarily is where people are asking for hearings to be adjourned because of the current crisis, particularly in circumstances where those hearings are perfectly capable of being conducted either by video or by telephone. There's been a couple of cases in the DIFC court that I'm aware of, and many cases in England that I'm aware of where the courts have refused to adjourn hearings that have been listed for some time because one party has said that they'll have trouble dealing with the technology required to do the hearing virtually.
Okay, thanks, Patrick. One more question related to the experts. How will experts appointed in the local jurisdiction verify the authenticity of evidence that's submitted online?
That's a good question. If the document in question is one that has been created electronically, then there's obviously forensic stuff that can be done to that document in terms of metadata to determine when the document was created. What's more difficult in the current climate is the physical examination of original hard copy documents. Not impossible. Handwriting experts are still able on e-copies to make an assessment as to whether a signature is genuine or not. The physical examination of hard copy documents would be delayed in the current climate, but is not impossible.
Okay, thanks, Patrick. And also, I know you touched upon this in your last slide, but there's also a question on what measures should the tribunal take to ensure witnesses are not being prompted off screen, which is a big problem.
There's a couple of things. Firstly, there's in the hearings that we have conducted virtually so far during this pandemic that have involved witnesses, the tribunal or the judge has given a very stern and serious warning at the beginning of the giving of evidence stage of the hearing as to any prompting or talking off camera going on. In one particular case, the rotating cameras were available and they were controlled by the tribunal, and the tribunal did on a regular basis during the giving of witness evidence move the cameras to see if there was anybody near any of the witnesses. So those are the sort of methods that are available to ensure that a witness is giving their evidence rather than somebody else's.
Okay, thanks, Patrick. Patrick, I know that we've reached 3:55 right now, so I think we've covered mostly all the questions that we have in hand. Do you have any closing statements?
Only really the last point that I was going to make, which is that
Right.
it is possible. It is possible to resolve your dispute using these formal forums, using the technology that's available. People shouldn't think that there will be any serious delay in obtaining justice at this time.
Okay. Thanks a lot, Patrick, for taking time off your schedule to share with us today. Definitely practical advice that everyone can apply during these difficult times. I'm sure if there are other questions, dear delegates, please do send it over to us and we will try our best to answer them. With that, we've come to the end of the webinar. Thank you, Patrick, again for your time and taking us through the topic and offering us practical advice on how to effectively prepare for and manage disputes in the current crisis. Our sincere thanks to the firm Charles Russell Speechlys and also to LLoyd Michaux for their support. Our thanks also to Hoda Mana of Charles Russell Speechlys for her help, and also to my colleagues Sunil and Sandhya at Niche Publishers for their support in ensuring a seamless session. Thank you for joining the session, dear delegates. We will definitely be in touch with you post-event as well to address some of the queries that we may have missed out. We will keep you posted of other events in the webinar series. Also, if there are any specific topics that you think we should address in our series, do write to us and we'd be happy to consider it. Thank you for your time. Thanks, Patrick. We wish you good health and have a great week. Thank you. Thanks, everyone.